guests, and my good friend, the Governor of Kilifi, Honorable Mungaro. Let me also say that I shall follow the President and adopt the very elaborate protocol schedule that was read out here. So, distinguished guests, ladies and gentlemen, good afternoon. I am here to represent His Excellency the President, Dr. William Ruto. There's been a bit of change in certain things. The tradition has been that cabinet sessions are held on Thursday, but since he came in, it's been moved from Thursday to every Tuesday, every fortnight. So today coincides with a cabinet session, and because of the importance he attached to this day, because I was present when he made his commitment that he would come in the Chief Justice chambers, he said that he shall excuse me from cabinet so that I can come here and represent him today. So let me proceed. I am privileged to join you today as we mark this important milestone in our institutional journey in commemorating the establishment of the Environment and Land Courts. The people of Kenya concretized their family-held conviction that the historical context with colonial claimants must be resolved in favor of Kenyans. The Constitution therefore determined for all time that Kenya is our home and that this land is our land. The establishment of the dedicated institutions for the governance of land and environment is an extension of this aspiration and affirms our commitment as a people to steward our resources as faithful trustees of present and future generations. The land and environmental governance is a domain characterized by interesting tensions that must be resolved to accommodate our aspirations for development and concern for ecological integrity, intergenerational equity, land and environmental practices that are also expressions of communal and cultural identity, and the relationship between modern science and indigenous knowledge systems in conserving biodiversity whilst actualizing economic growth. As a charter to inspire Kenyans in their quest for sovereignty, equality, sustainable development, equity, and sharing of resources, and other national values and principles of governance, our Constitution calibrated a sustainable balance to arbitrate inevitable tensions while firmly steering the nation along a progressive and radically transformative trajectory. Natural resources are vital for human well-being and national development and economic growth. In Africa, the legal system pertaining to land and natural resources has overwhelmingly tended to reflect exclusive and unlimited access by powerful groups, accompanied by their exclusion and marginalization of a subordinated majority. In other words, the institutional framework around land and environmental resources has traditionally been characterized by severe coloniality even after the achievement of independence. This institutional characteristic is a key driver of poverty and inequality and an insurmountable barrier to the attainment of sustainable development. The promulgation of our Constitution as an intentional instrument of decolonization in 2010 therefore represented the realization of the fundamental aspiration driving the bitter resistance to colonialism and brave struggle for independence. This driving force was the quest to regain control over land. Similarly, Kenya's history with regard to natural resources is firmly united with our people's struggle for environmental justice. Once upon a time, state power, government institution, the legal framework, and judicial decisions were organized to achieve and maintain the effective expropriation of Kenyans for the benefit of a colonial minority. Today, they are strategically coordinated to align land, natural resources, and environmental governance with a broader intention to achieve sustainable development. This transformation in the nature, content, and direction of our constitutional, statutory, and judicial system was realized when the objectives which inspired the freedom struggle were finally articulated in our Constitution. It is important to underscore the history, institutional implications, and transformative significance of the Land and Environment Court system in order to establish a sound analytical backdrop against which we can properly appreciate our progress since August 2010. The Constitution mandated a robust Bill of Rights with clear social and economic rights, including the recognition both strong rights and equally effective obligations with regards to the principally land-based phenomena of the environment and natural resources. It also expanded access to justice, mainly by relaxing the rule on standing and the requirement that substantive justice shall prevail over preoccupations with form and technicality. This pioneering approach to land, natural resources, and environmental justice hardly had precedent in our continent and set the stage for the actualization of Kenya's potential to unlock the plenty that lies within its borders. An evaluation of the jurisprudence that has emerged and steadily evolved establishes land, natural resources, and environmental justice as a foundational elements of radical socio-economic transformation and guarantors of sustainable development. In its capacity as an environmental court, our Environmental and Land Court has also emerged as a salient proponent of climate justice, establishing the constitutional principle of equitable distribution of the benefits as well as burdens of climate change. The ELC has also emerged as a powerful champion of the Sustainable Development Goal adopted by the United Nations General Assembly in 2015. This caliber of emerging judicial leadership has enabled Kenya make progress in fighting poverty while protecting the planet by focusing policy formulation and implementation frameworks on the beacons of people, planet, prosperity, peace, and partnership. Kenya is firmly committed to the achievement of the sustainable development by 2030 through the development blueprint in Vision 2030, as well as our plan to drive rapid socio-economic transformation in order to attain shared prosperity. For this reason, we have invested effort and resources in various frameworks, including the National Climate Change Response Strategy and the National Climate Change Action Plan, out of realization to enhance resilience and adaptability to shocks exerted by adverse impacts of climate change. These imperatives make it a critical priority to tap into all available potential, including domestic and international, as well as public and private resources, through effective articulation of climate justice. The ELC holds potential to render tremendous contribution in this regard. The ELC, therefore, has a clear and direct judicial mandate that it must continue to discharge with utmost fidelity to the law and the public interest. It also has a cardinal responsibility to anchor discourse on justice and sustainable development. We look to this conference with great confidence because we expect the court, in conjunction with its partners and other stakeholders, to tackle critical issues connected with enhancing the greening of justice, governance, and the law for effective land and environmental management. The role of technology in advancing this agenda must also have a share of your attention. In particular, digitization of land records will present fresh opportunities to accelerate the realization of land justice, creating advantageous conditions for rapid economic growth. Furthermore, this conference will find ample opportunity to exhaustively consider the adequacy of public participation and access to justice in land and environmental matters, climate financing, women and land rights, climate change, urbanization, and disaster risk management. I also note that the court will also launch its strategic plan for 2023 to 2027, which will provide an opportunity for it to build on successes so far, as well as lessons and remedial actions arising from the implementation of the previous plan. The court will also launch 2 other publications, the casebook and the information end-to-end booklet. These publications go a long way in enhancing public knowledge of the court and its processes. I commend the judges for their tremendous contribution to national tree planting. The planting of 100,000 trees in 36 court stations between July and November this year is a highly appropriate gesture that is fully aligned with the court's mandate. It also demonstrates a commitment by judges to provide leadership in efforts to combat desertification and mitigate the effects of climate change. Finally, the judiciary has provided an effective model of how responsible citizens contribute to the greater good. Congratulations. I reiterate the government's commitment to fulfilling its portion of responsibilities to facilitate the court in order to support sustainable access to land and environmental justice. The government pledges to enhance financial support aimed at establishing more ELCs with the objective of eventually having them in every county. On this note, I take this opportunity to wish you fruitful deliberations and look forward to considering their outcomes in due course. Thank you, and God bless you. Now, anything else I say is not the President's remarks. At a personal level, let me just say that indeed I enjoin the previous speakers in underscoring the significance of what has been achieved so far and what we look forward to as we go forward. I'll go straight to the point. I think somewhere the Ministry of Lands is lined up to be here, and other key players. I've seen the chairman of the Law Society or president of the Law Society and other people who are here who are movers and shakers in their own right. I want to state that indeed we have received some genuine representation that the processes at the Lands Office have become inimical to the growth of business. There are inordinate delays in the processing of instruments that are required either to unlock financial resources or to propel certain transactions. As you deliberate here, I would strongly appeal to you, kindly look at that area critically, dialogue with us so that we can partner in making sure that we can unlock what is estimated to be close to 100 billion shillings of resources that are not being released into the economy because there's some inordinate delay at the lands registry on matters that are very critical. If you want to spur the economy, generate jobs, boost our earnings as a nation, we must unlock these resources. So as patriotic Kenyans, let's reflect on it and let's ask ourselves, individually and collectively, is it my act of omission or my act of commission that is deliberately delaying and slowing down the economy of this country? If you can internalize that, and if you feel that you have been partly responsible for it, kindly change your ways. And if you change your ways, then collectively we shall have changed our ways and we shall be able to unlock the potential that we also desire to get our economy growing rather than continuing to see poverty strangling us. So ladies and gentlemen, have a fruitful deliberation and help us to unlock some of these challenges. God bless you all.